Good morning, good afternoon, and good evening. Thank you so much for joining us. I am Professor Dr. Luis Maria Palma, President of the International Association for Court Administration. Today, we are developing the 5th session of the online conference program jointly organized by IACA with the State Judicial Administration of Ukraine, the EU Project Pravo-Justice, and USAID Justice for All activity. This conference is dedicated to gender approach into the justice system. The topics to be covered by the outstanding speakers of this session are implementation of a gender approach into the justice system of Ukraine, best practices in organizing court proceedings in a gender-sensitive manner, gender issues in court proceedings and war crimes adjudication. Ms. Yevgenia Bondarenko, national expert of the EU Project Pravo-Justice, and I will serve as the moderators. Now I'll summarize again the rules for the session. The online conference will be recorded. We'll introduce each speaker before the presentation. After all the presentations, there will be approximately 10 minutes for questions and answers. We'd appreciate if you could send us your questions using the chat box and identify the speaker to which they are addressed. We kindly request you to mute your microphones. Please, Ms. Yevgenia Bondarenko. Thank you.
Дякую, докторе Пальмо. Щиро вітаю всіх учасників цієї конференції.
Thank you very much, Dr. Palma. I'm very happy to welcome all the participants to this conference. Today we are going to discuss a very sensitive issue, which is a gender approach in the justice system. It will not take more of your time and will give floor to honor the lawyer of Ukraine, deputy head of the State Judicial Administration of Ukraine, Olha Bulka, who will intervene and tell about implementation of a gender approach to the justice system in Ukraine. Olga, the floor is yours. Thank you very much. Dear participants, thank you for having me here. I will try to speak very shortly but comprehensively about some practical experience of the implementation of gender aspects in the activities of the State Judicial Administration of Ukraine. In the first place, I need to mention that in Ukraine there is a series of the list of pieces of legislation and regulations which are aimed at equalizing the approach and treating of both men and women who are users of the judicial system. These documents are in place for a while, and now the development, next slide please. At this time, the development of the above mentioned issues has gained new momentum with the support of international donors such as USAID, Pravo-Justice, and other partners. During years 2018-2023, a list of regulations was developed. These regulations are aimed at the introduction of gender approaches in the activities of the State Judicial Administration. Besides, a specialized unit was designated to oversee the implementation of the above-mentioned regulations and to counteract to violations of the above-mentioned pieces of regulation. Besides, the head of the State Judicial Administration was empowered to oversee the implementation of such regulations. In addition, a specialized position of the HA head counselor was introduced to be responsible to bear responsibility for the implementation of the newly adopted provisions. Besides, in the state judicial administration, we hold analysis and hold oversight of local regulations in order to check their compliance with the general policy of counteraction to gender-based violations. The state judicial administration constantly oversees the above-mentioned issues. Besides, the State Judicial Administration of Ukraine has become the very first institution within the judiciary which held a so-called gender audit. Back in 2017, with the support of a Canadian project, the gender audit was held. The audit covered the state judicial administration of Ukraine only. As a result of such gender audit, some strengths and weaknesses have been identified, which led to the development of respective recommendations and guidelines. Respective needs have been identified, and the most important deliverable of that audit was the gender strategy developed in the state judicial administration. The strategy was developed for the years 2021-2025. The strategy set up 5 key goals. The implementation of the strategy will allow a comprehensive gender approach to be implemented. It will contribute to strengthening of institutional capacity, performance. It will facilitate greater accountability in the state judicial administration, and finally, it is aimed to facilitate better communication and greater establishment of relations of partnership between the state judicial administration of Ukraine and other stakeholders. This year, the intermediary analysis of the strategy implementation was held, which covered the 2-year period of the strategy implementation. Their respective results have been properly recorded, and we hope that the strategy has become the first step towards the development of the overall gender strategy for the whole Ukrainian judiciary. Unfortunately, there is no such strategy in place as of today. Now, let me speak about some practical steps and results achieved via the strategy implementation. Thus, in the framework of the audit, the state judicial administration holds the gender analysis of the composition of local and regional courts, as well as the SJA territorial units. The respective results are available on our official website. What we also do is holding analysis of internal documents to check them for compliance with overall gender policy, the principles of non-discrimination, and so on. It so happened that the courts have to deal with some gender sensitive issues when actually performing its functions. Thus, in 2021 and 2022, the State Judicial Administration has held a gender analysis of some 50 regulations and of the headquarters of the SJA headquarters and some 1,000 documents issued by the territorial units of the State Judicial Administration of Ukraine. Besides, we have organized events aimed at prevention of sexual harassment at workplace and other types of gender-based violence. As I have already mentioned, one of our key goals consisted in the improvement of judicial statistics. In particular, via the improvement of documents for respective forms for collection of court statistics. For instance, now we have specialized blank forms which allow recording the gender of victims, whether they are men, women, children. This statistics is properly recorded, generalized, and placed in a anonymized form on the official website of the State Judicial Administration. So these activities are held in particular as a part of the nationwide effort to improve the state of play in the gender-related issues. So our statistics becomes a part of statistical data collected by Ukrainian government. Besides, the State Judicial Administration hold cooperation with various international programs for addressing gender related issues, in particular with the USAID project. Our another goal is to create safe spaces for court users in court premises, in particular when it comes to gender sensitive cases. To this end, we hold cooperation with international donors, for instance, with the EU Project Pravo-Justice, who provided us with a manual or a brand book, model court brand book, which contains information about the equipment of special safe zones for vulnerable witnesses, vulnerable victims, for participants to court proceedings with children. And as a result of such cooperation, 143 trainers were trained to deliver trainings on vulnerable on delivery of services for vulnerable witnesses. Besides 17 courts across the country have volunteer services with the overall number of volunteers going up to 300. On the website of the State Judicial Administration of Ukraine, there is a special tab on gender equality issues. This page contains various information and statistics on gender equality. It contains information about implementation of a gender approach in the state judicial administration and success stories of women in the judicial system. In January 2023, we held an anonymized survey among the SJA employees in the headquarters and in the territorial units. You can see the results in the screen. Some 70% of respondents believe that the gender policy is properly taken into account by in the policy and programs of the SGA of Ukraine. Besides, some 90% of respondents believe that the State Judicial Administration of Ukraine does enough or more than enough to counteract or prevent gender-based violations in the judicial system. In the meantime, there are, of course, some drawbacks. For instance, there is the lack of proper taking into account of needs of men and women when developing corporative policies and requesting for respective funding. However, here I need to say that when making the budget request to the Ministry of Economy of Ukraine, all the gender-related aspects are taken into account and properly articulated in the documents submitted. However, sometimes this effort is of purely formal nature and does not translate into any practical result.
Or neighbors, also between victims and perpetrators and the parties to the court proceedings. Also, there is a need for systematization and improvement of the overall practice in court operations. I presented information on taking into account these gender aspects in the territorial units of the State Judicial Administration. Now let's go to the next slide. Of course, each of us will agree that the full-scale war in Ukraine has shifted temporarily some priorities in the activities of each bodies, including the State Judicial Administration. However, the gender approaches in the activities of the State Judicial Administration are not fully on hold. We are interacting with international partners. We continue our interaction with the USAID Justice for All activity when it comes to the gender sensitivity in the judiciary, and that its involvement will also go into the gender sensitive cases to further take them into account when analyzing the cases, and also some. Actually, now I have covered briefly the activities of the State Judicial Administration, and all our contributions are posted on the website of the State Judicial Administration. You can look it up. First of all, thank you so much to every State Judicial Administration staff member, especially Natalia Makarova, because she is really into this topic. Thank you so much for your intervention. Indeed, it's hard to prepare so much information and present it, and I want to say that each of you will have access to these presentations. Now, not to take up any more of our time, I'll give the floor to Tatiana Fuley, PhD in law, awarded lawyer, and the head of the Department of Methodological Support of the State National School of Judges of Ukraine. Will be speaking about gender approach, but from the standpoint of education. Our experts are very much requested to deliver their interventions within the timeline, and everyone who wants to ask something, please feel free to write them in chat. At the end of the event, we'll discuss them. Dear Tatiana, the floor is yours. Thank you, Evgenia. Dear Dr. Palma, dear participants of this online conference, thank you for your attention to this topic at such challenging time. Indeed, the opinion from the standpoint of legal education and gender approach, I want to clarify here that the National School of Judges of Ukraine provides training for judges, for judicial staff, and for candidate judges. That's why we have some specific features in training of each specific groups. I'll be speaking of judges mostly today. And just as a brief reminder, I'm sure you've heard that this National School of Judges of Ukraine is guided by the national standards of judicial education developed almost 10 years ago. In 2014, we first set this bar for ourselves. We drafted standards. And each training course and each curriculum are aimed at not only developing knowledge, they have the knowledge component, but they're not the only one. It also is aimed at getting or improving skills and what we call the values in judges. Therefore, these three dimensions, to put it this way, knowledge, skills, and values, they are the most important ones when it comes to the development of each course. I'll be speaking of three questions today. First question starts with the following slide.
Друге, що зробила школа за
Shows
останні
why it's important, then what the school did over the last couple of years, and then our further improvements. As far as gender sensitivity is concerned and where this term comes from, it goes without saying that there is 33rd recommendation of CEDAW when this term has to do with the whole judiciary. As we see it, only one paragraph, only one that has to do with both the judicial system and a number of other notions, and therefore what we are used to consider as international standards, and traditionally we see here as independence, impartiality, efficiency, etc., but it's not only it. Also, current international standards demand that the justice system be gender sensitive. The next slide shows only a couple of terms where there is some feature of gender sensitivity, not only just the system and components, but also procedure,
Підхід, спосіб розгляду справ,
mechanisms to deal with issues such as property settlement, land rights, inheritance, manner to handle cases, approach, dispute resolutions, judgments, or decisions, etc. So we speak here not only of decisions, but also of other components. How did the school react here? Here you see the cover page of the publication. In Ukrainian, this publication is available at the website of the National School of Judges of Ukraine. It's the first survey we carried out with the involvement of OEC project. It's exploration of gender equality and discrimination among judges and advocates. This presents not only the findings of the survey, but also contains an overview of the then ECTHR jurisprudence in cases related to gender discrimination and other cases that can be considered to be gender sensitive, and specific recommendations for judges, for lawyers. 2015-2016 when this was presented. I can tell you here straight away that in 2016, in June, this was presented at the first All-Ukrainian forum dedicated to gender aspects in the operations of judiciary. Then judges, court staff members, court administrators could ask this question and could voice out the challenges faced, and I sincerely hope that international technical assistance projects will continue this and continue supporting this initiative, because time flies by. This initiative was started in 2016, but it wasn't settled as annual or biennial initiative. And from that point, when there were some specialized courses, both the general topics and specific topics. Next slide shows one of our courses developed for judges trainers of the school. It's gender equality through the light of prohibition of discrimination and the light of ECTHR jurisprudence. And it had to do with gender equality when dealing with labor cases. We chose the labor cases on purpose because it was the only field where there were officially recognized problems of gender equality and facts of discrimination, and that there were some decisions by Ukrainian courts. We tried to make this course practically oriented, and after that we worked on a number of activities. What you can see right now, the cover page had to do with the target audience being the trainer judges. It takes into account administration aspects, communication, and the roles of the president of courts or deputy presidents of courts, that is administrative positions they hold outside the administration of justice. It shows the course that we developed, what we developed for judicial candidates, and it actually had to do with the time of pandemic, and it was presented during pandemic on dealing with gender stereotypes. The development also had to do with the fact that a complex government program was developed, and that there was request as the educational establishment to overcome these gender stereotypes. It goes without saying that challenges had an impact, both at this event. It's a pleasure to see here Christina Kitt. Greetings to you personally and your fam. We had a number of events, and one of them was in cooperation with your fam on applying the principle of gender equality and the prohibition of discrimination in light of the challenges related to armed conflict. In this June, that was this June, and it goes without saying that war had an impact on some topics and on what we are delivering during trainings. Apart from the courses that have to do with general aspects, we also have specialized cases devoted to domestic violence cases, to the sexual violence that was committed during conflict, that is CRSV, and we also see some topics that are included in periodic training for general courts judges. It's to put it very briefly, given the fact that we are really low on time, we see that the National School of Judges of Ukraine presents both some separate projects. Dear Tatiana, you have just a minute because we have some speakers who really need to deliver their interventions as per timing. So I just want to say that it's important to ensure that gender equality is introduced horizontally, apart from some courses devoted to gender issues. It's very important that judges recognize the gender aspects in the management of the courtroom and considering cases that were committed against life or some other violent crimes when considering war crimes, that is irrespective of the topics or the challenges of some specific categories of cases that they were considering. And to finalize, just a couple of sentences, what can be done? It was a pleasure to hear from Uliana that we see some statistics. However, really, we do lack such statistics. There isn't enough of that, and that's an aspect that can be the background or the foundation for further surveys. We have annual reports as per jurisdiction, and of course, in criminal justice, there are a couple of gender disaggregated statistical data items, but the administrative justice or commercial jurisdiction, it's only about cases and case files. We don't see people as such, neither men nor women. And in civil cases, it's a little bit better, and I presented a screenshot of the civil jurisdiction proceedings. We can see that there is one general number that shows that the number of applications to courts by individuals, out of them men and women. However, this data poses some questions. They are not in line because if we look at men and women, and if we can compare it to the number of applications by individuals, we see about 176,000 people. It's not clear who those people are, and where is the rest? And answering the question by Olga, the criteria for determining gender-sensitive cases, here we need to look at the example of other countries that started such statistics. How many people go to court, who of them are men, who of them are women, what is their background, and then we can see what aspect of social roles and what aspect of gender component can be present. Thank you so much, dear Tatiana. Ready to answer your questions. So we will surely come back to this discussion while Q&A session. Now I'd like to give the floor to Christina Kitt, who is a very well-known person in this area in understanding the gender and even introducing terminology to be used actively, feminine forms for lawyers, and the other legal professionals. So Christina Kitt, the advocate and the president of the EURFEM, the NGO devoted to gender issues. Hello, dear colleagues. Here in my short presentation, I'll cover what was already mentioned by my colleagues. So I'd like to mention the gender sensitivity index in terms of the judiciary and this gender sensitivity issue. That's where we worked on before the full-scale invasion. And if we had to update it today, I guess we would have a different look at it as to what must be reflected in this gender sensitivity issue. And in terms of the gender sensitivity and the judiciary that was prepared by USAID project, I guess it was 2021 when we reviewed this index, and this index is made up of 4 blocks. First block is about leadership and the gender balanced approach. The second one about training programs, the things that were mentioned by Tatiana in detail. Third block, it's about using gender sensitive approach in gender sensitive cases, and in this index we tried in this indicator we tried to see what can be taken into account as gender sensitive, and then monitoring data that as to gender discrimination in gender sensitive cases. The only thing that was already mentioned by Olga and Tatiana, I'd like to mention that it's very important to focus our attention on monitoring and analysis of gender analysis and approaches when we speak of considering. Christina, sorry, they can see the presentation. Please have it full scale. I guess I did it. Just let me try again. Oh, we can share.
Так, видно?
О,
Має
так,
бути.
так. Якраз ви
Чудово.
Нас
на
бачимо.
слайді структура індексу.
На слайді по блоках, так, 4 блоки. Отже, власне, я зупинилася на тому, що якщо говорити про
That's where I was. So speaking of the statistics, when we touch upon the first block, leadership in the judiciary, we can see the following. The number of female judges is equal to male judges, so 50-50, but when we go, so everything is good in terms of the judiciary core, but if we look at the court staff, we can see more women there. I think it is related to the scope of remuneration and workload in the court apparatuses. So some efforts need to be made in order to attract more male employees. If we look at block 2, which is about training programs and gender aspects when developing training programs for judges. So we have new challenges and new needs here, in particular those related to the war. Some gender sensitive, the number of gender sensitive cases has increased. there are more vulnerable victims and witnesses, and this need to be taken into account when training judges, in particular on adjudication in various cases related to the conflict. Another important block is about communication and gender-sensitive approaches in communication. It is something which we are trying to address together with international partners and international donors. Last year, many of us, well, actually all of us witnessed, and many of us can remember scandals related to coverage of CRSV cases, and this block is important from the standpoint of training and shaping the necessary skills and knowledge about how gender-sensitive cases should be covered in the public, in the wide public, for the wide public. And finally, block number 4, which is monitoring of data related to administration of justice in gender discrimination related cases. So this has been partly covered by the previous speaker, Olga Bulka. So proper monitoring is needed, especially in the light of the current realities, which are full-scale invasion, wartime, and the regime of martial law. Olga mentioned today the gender strategy of the judiciary. I will also only add that the SJA gender strategy may become a basis for the development of a wider and more comprehensive gender strategy of the whole judicial system. We have tried to negotiate and include the gender equality unit to the nationwide restitution plan. So anyway, the effort in this direction need to be multiplied. Now, going further towards the recommendations. We have already come up with the idea of setting up a special working group on gender issues to promote gender-related agenda at the governmental level. Besides, we articulated the need to update the gender sensitivity index in the activities of judicial institutions. Besides, we have suggested to hold the additional survey aimed at update of information and on the state of play in the judiciary in terms of gender equality. It is also important to continue working on gender-sensitive issues. Christina, my apologies. We have some time limitations, so please mind your timeline. So, okay, I will try to wrap up shortly. My point was that there is a need to continue working on gender-sensitive issues, which are common and overlapping for the judiciary as well as for law enforcement bodies. Thank you very much for your attention, and I remain in your disposal. Thank you very much, Christina, and I turn it over to Dr. Palma.
Thank you so much, Ms. Kitt, for providing this enlightening presentation on the importance of information processing and specific training to properly monitor how the management of such a sensitive issue evolves. Now we'll continue with the presentation of the following theme: best practices in organizing court proceedings in a gender-sensitive manner. Please, Mr. Makin Hatkett, international expert of the EU Project Pravo-Justice, international prosecutor and barrister. The floor is yours, sir.
Thank you, and thank you for having me
Дуже дякую за запрошення.
speaking at the conference. I just want to approach this from the perspective of best practices in organizing proceedings in a gender-sensitive manner. And what I mean by that is the moment that a victim comes through the door, right the way through to the moment that the judge delivers the verdict in a case, and in many ways beyond that too. So in the short time that I have with you today, I just want to try and emphasize, I think I've done this a lot in a number of talks that I've made within Ukraine, is to try and emphasize the joined up approach that has to be taken in cases of gender sensitive matters. And when I say that, from my perspective, I mean cases that involve conflict related sexual violence and sexual gender-based violence, and also violence and sexual offences against children. So first of all, from an investigatory perspective, it is important in my submission that from the very start, the investigator in the case, who is the first responder and the first person who the victim will come into contact with, is first of all trained, but then acts in a way which is sensitive to that victim's gender and the specific needs. And this can often be seen in cases where there are historic complaints of a sexual nature. Because what investigators and prosecutors, and I think also judges, need to do is to try and put to one side any preconceived attitudes that they have as regards what they think a victim should act in a way in any particular circumstances. For example, in many sexual gender-based violence cases, there is a delay between the actual offence and the victim being attacked or assaulted or raped. There is often a delay between that and the actual complaint to any investigative authorities. Now, that delay can be weeks, it can be months, and in some cases that I deal with, certainly in the United Kingdom, it can be years. Now, those sort of cases, in my view, need a very specific approach to try and understand that for victims of sexual violence, there is no one set victim as regards how that person will act. Some victims will act and make a complaint almost immediately. Other victims will internalize, understandably, the traumatic events that they have been experienced too, and they will not complain about matters until a number of years later. So for investigators and prosecutors, those being the first responders, taking the first accounts from those victims, it's important that there aren't any preconceived ideas as regards the way a victim should act. all victims are different, all victims will make a complaint in a different way, or all victims will give evidence in a different way. So from that very beginning, there needs to be a gender-sensitive approach as regards the obtaining of the statement and the understanding that the investigator and prosecutor gives towards that victim. And when I say understanding, what I really mean for that individual to listen, to ask simple questions, and to act with humanity, being aware of the gender-sensitive issues. And that ties back in with what I first said about the training that's required. And sometimes I think mentoring for people who will be the first responders to deal with people of gender-sensitive violence. So what my views are as regards organising best practices is that, first of all, we need proper training. Then we need investigators and prosecutors who are sensitive to these issues, not only from a training perspective, because as we all know, some people can go into training, but and then not follow that training through into how they practice. What it is so important is that those trainings that investigators and prosecutors are involved in are then followed through into actual practice. Because, and I was making some notes just as I was listening to the other speakers as regards what I was going to say in my very brief presentation. And I was thinking in the end, why do we seek to adhere to best practices? There's a number of reasons for that. First of all, we want to try and get the best evidence from the victim. But also what we want to do is to try and treat that victim with humanity, being aware of the gender-sensitive issues, so that that victim is not re-traumatized or not additionally traumatized in having to speak and give their account. So it's so important from many different perspectives that within the criminal justice pathway, that investigators, then prosecutors, deal with victims in a way in which will allow those people to give the best possible account in the best possible circumstances. When I say the best possible account, I'm saying the fullest account possible as regards what they remember of the traumatic effects of the incident that they were subject to. So, for example, I prosecuted a case, a war crimes case, when I was in Kosovo, which involved a male victim. And that brought its own issues as regards gender-sensitive practices, because that male victim had been subject to genital mutilation. And he was tortured, he was beaten, but also his genitals were mutilated by his attackers. That required me to put in place the best possible services in order to allow him to give his account to me, and also to follow through on that account and give his account in court. So it meant the use, and this has already been mentioned, of safe zones for vulnerable victims. It meant the use of video recordings of that evidence within that safe zone or green room, I think a term has been used, I've heard in a Ukrainian context, and the playing of that evidence in chief to court. When he was then questioned, he was questioned over a video link, and he was at a remote, secure location with a member of court staff, with somebody from the psychological services to hand. So it's trying to put these experts in place and various practices in place in order to make sure that that witness in that particular case, because not only was the offence a very gender sensitive one in his particular case, but that person, because of the nature of the defendants, and this is also an aspect in a gender sensitive case, he was at physical risk also. And I think, again, this is something that we have to bear in mind as regards gender sensitive cases, it is often the case that offences of conflict related sexual violence, of sexual gender-based violence, of sexual violence against children have been committed within a power relationship where the perpetrator has held power over the victim and has exercised that power by offending in this particularly awful way. So again, that's another feature that an investigator has to be aware of, and a prosecutor, when trying to make sure that the proceedings are properly put in place in order to get that witness from investigation through to giving evidence in court. So if I just move on a stage, that victim has given an account to a prosecutor and investigator, there has to be explanation, obviously, as regards informed consent. The victim has to be encouraged to ask questions. But what is also important, in my view, is that once that victim is interviewed and that interview is recorded, that victim is simply not sent away without any contact details, without any support, and merely told to come back to court in a few weeks or a few months' time. It's important that there are liaison officers in place, that a victim is provided with the most simple things, a telephone number, an address, a name, so that victim can be told, look, if there are any issues or any questions that you have, ring this number, visit this drop-in centre, speak to this individual, and we will provide you with support. And again, that links in with making sure that that evidence is preserved, making sure that that victim is looked after, and making sure that that victim is in the best possible place, minimizing re-traumatization in order to come to court and give evidence. If we then take it a step further, when it comes to the day of court, it would be my recommendation and practice that prior to the victim having to come to court and give evidence, that victim is allowed to attend court with an investigator or a prosecutor, and the basic layout of the court is explained to them. Everything being explained, in my experience, puts that victim at ease, and again maximizes the chances of that victim being able to give the best possible evidence when the court day comes. And again, the visit to the court, that will encourage questions from the victim. That victim can be reassured, and it also depends, in my view, about the prosecutor putting best practices in place so that that victim can give evidence, maybe in the courtroom, but in a separate room from the actual courtroom, in order that their evidence can be placed into court via a video link, so that that victim does not have to physically face the perpetrator within that courtroom, and that the court can properly hear that evidence and assess its probative value without the victim or his or her evidence being affected by a possible confrontation between the victim and the perpetrator. What I would also suggest, and this has already been touched upon, is judicial training. So we've got investigators, we've got judges, we've got prosecutors, and I will come on to defence lawyers as well. So judicial training, not only to challenge any judicial preconceived ideas about how victims may or may not react, but also so that judge can better manage the courtroom and better manage the presentation of the evidence as between the prosecutor and the defence. Because once the victim is given evidence via the prosecutor, and the defence are then required or allowed to ask questions of the victim to test that victim's evidence within the overall process of a fair trial, it is important that the judge make sure that the questions from the defence lawyer are properly framed. And again, those questions should not be aggressive. They should stick to the relevant issues in the case. If there is an issue about consent, then those issues should be dealt with as best and as carefully as possible by defence lawyers under the supervision of a judge, so as not to offend any fair trial principles. But I think it's also necessary that defence lawyers, their role is recognised within the system, and that they have proper training as regards how these cases that are gender sensitive will be processed within the court system. And that will allow them to do their job better. And it will allow, if they can do their job better, get to the point and ask relevant questions, it then means that the victim is subject to less traumatization overall. And it will allow the court to make a more objective decision, in my view, as regards the evidence. I think what's also important from an evidence perspective, an assessment of that evidence, and I say this as a prosecutor and also as somebody who often works with judges as regards the analysis of this evidence, is that sometimes with victims of sexual violence, certainly if there has been a long period between the offence and the complaint to the authorities, there might not be any corroboration. And I think sometimes the temptation is by prosecutors and by judges to think less of the case and less of the complainant, first of all, because of the delay, and also because there's not corroboration. Now, in many occasions, because of the nature of these gender offences, these offences have happened behind closed doors. If it's in a domestic violence setting, there aren't any witnesses. If it's a rape that's occurred 10 years ago or 6 months ago, there is no DNA evidence. So it's important that I think prosecutors and judges keep an open mind. And in the particular case in Kosovo, we didn't have any corroboration, save for some injury marks. And my submission to the judge was, you've heard this witness. That witness has been cross-examined. That witness's evidence has been tested. My submission to the judge was, you can accept that that witness is telling the truth. It's a very simple submission. They've given evidence, they've given detailed evidence. You don't need to look for any more corroboration if you believe what that witness says. And I think for me, that's an important message to prosecutors and judges when they come to consider these sorts of cases. I've gone through very quickly. I hope I haven't overstepped my time on this, but I hope I've covered my views as regards best practices from investigation through to the ultimate delivering of the verdict. But my final point now would be is that after the verdict, the victim should not just be put to one side and left to their own devices. One of the most difficult jobs I have as a prosecutor is going to see the victim after the verdict has been delivered in a sexual violence case, if the defendant has been found not guilty. And remember, it's a fair trial process. I've got to go and tell the victim the court has found the defendant not guilty. I've got to then go through the reasons to a distraught victim as to why that might have happened. So that's explaining to the victim about the burden and the standard of proof, that the court may have been looking for some additional corroboration, and the court might not have been able in the circumstances to feel that they could be satisfied beyond reasonable doubt, that very high burden that the prosecution have in order to prove the case. But what I try and do is say to the victim, I am not saying that I have not believed you, but we are working within a criminal justice system where there is a very high burden to try and prove offences of this nature. There has to be follow-up as well as regards the victim, whatever the result. There has to be made available to the victim the relevant psychological services and also any services as regards the possibility of compensation within the Ukrainian system. But also it's often the case that victims may well have an additional story to tell as well. And the victim, after one case, I was raped on one occasion, the trial is over, may then spill everything out and give other accounts of what may or may not have happened to them in the past. So at every stage of the process, me as a prosecutor, investigators and judges have to hope within the difficult context of a trial and a criminal justice pathway that we try and be aware of the necessity for a gender-sensitive approach. And my simple principles, and I think I outlined these to police officers 2 weeks ago in Ukraine, is to listen to the victim, keep questions simple, and always, always act with humanity and respect. Thank you.
Thank you so much, Mr. Hackett, for such a profound presentation on best organizational related practices on the gender-sensitive approach regarding victims' protection, including war crime cases and the necessary preparation of investigators, prosecutors, and lawyers to fulfill their duties to the best of their ability so justice can be properly served. Please, Ms. Alicia Davis, Principal Court Management Consultant with the National Center for State Courts. Ms. Davis, the floor is yours. Thank you.
Thank you so much, Dr. Palma. And thanks to all of you. It's a tremendous honor to join you today. And I will say that I've learned a great deal. I admire your dedication to a gender approach. In my work as a consultant for the National Center for State Courts, I work with courts in the US and elsewhere, and in improving the administration of justice. And so I would like to limit my brief remarks today to the organization of court proceedings and a gender-sensitive matter. And it was interesting to me to hear from the preceding speakers how aligned we are in approach. So I'll be addressing 3 issues, and that would be governance and the establishment of gender and justice commissions. I'll speak to user voice, as well as the use of data and statistics. If we could pass to the next slide, please. So first of all, in terms of governance, I wanted to address the establishment of gender and justice commissions. There are a few examples of this in the United States, and I'm offering the best example, which exists in the state of Washington. And as you can see here, the chairs are, one is a justice of the Supreme Court, so the highest authority in the state, as well as a judge that sits, that currently presides over issues of gender violence. And it's in this manner that they are able to receive leadership from above, as well as the everyday experience of presiding over gender issues. This is the central gathering place where they put together all studies concerning gender. They present all statistics. They talk about policies and practices to be observed within the courts, such as those that Barrister Hackett was addressing. And these are all examples that you've given today of different aspects of organizing proceedings in a gender respectful manner. And in all transparency, commissions like this in the US are all too rare given the importance of the issues, but it really is an admirable example of the way to ensure that the courts are enhancing equal treatment of all parties and that they serve as a liaison between the courts and other organizations within the community to work towards a community that's free of bias. If we can move to the next slide. The next issue is that of user voice and the importance of, in any court procedure, that the user voice is central to the experience. So I wanted to present an example that our organization presided over in April 2022 on the heels of the pandemic. And in this, we had heard from so many courts about the exciting technologies that they had put in place in order to enhance the user experience in gender violence cases. And we wanted to ensure that during the pandemic and all of the rush to translate in court proceedings to the virtual environment, that the user voice was central and that nothing was lost in that experience and perhaps even enhanced. Because as we know, that technology can greatly assist the parties that are affected by violence. It can prevent them from having to leave a home, which can be the most dangerous time for a person affected by violence to leave a violent relationship. And so we brought together courts, we brought together staff, judges, advocates across the country to listen to what the experience had been. And from this, we learned that parties were experiencing that because of the pandemic, there was much less staff available to support them, that this presented a challenge. Oftentimes, the procedures were so complex that people had a hard time navigating, had a hard time knowing from which step to proceed, how to engage in the next step. We learned a great deal about, as a result of that confusion about the procedures, how that was impacting the issuance of orders of protection. We learned that community connections had been damaged in the translation to the virtual environment. And by that, I refer to access to advocates. In the US system in particular, the figure of the advocate is primordial. It is the person that can sit to the right of the person affected, can speak on their behalf, can ensure that they are able to present their information in a manner that the court can receive and take action. And so if that person in the translation to the virtual environment is not present, a great deal of support is lost. And so through these conversations, we learned how important it would be to reinforce community connections and ensure that that support was available. We learned other things, that the poor litigant experience, meaning that oftentimes the parties participating, the audio was insufficient, they weren't able to connect, there wasn't enough bandwidth, and that certainly affected their ability to proceed meaningfully and to seek the support that they needed. Language access is a significant barrier, and I'm happy to report that a number of courts have taken active measures to ensure that access is available in someone's native language. And there are a variety of languages that need to be accommodated in our system. And finally, technology barriers. And so from these conversations, we were able to establish somewhat of a checklist. And it's by far not entirely inclusive, but I thought it might be helpful. It was helpful to us to present a rubric to consider these various elements. If we could proceed to the next slide. So from this, in the implementation of any issue, of any policy affecting gender, we established this checklist to consider that there are the concrete user-centric issues, such as those barriers that we just looked at, the technology issues, the language barriers, the difficulties connecting with advocates within the community. But then there are the more abstract user-centric issues that parties coming before the court need to feel that the court is responsive to their culture, to their background. They need to feel a sense of procedural justice, that the forum in which they present themselves is fair. That forum also needs to be trauma-informed and aware of the experiences that bring the party to the court. It also needs to involve non-traditional stakeholders. One of the examples that came to us from the result of holding this forum is that a judge in one of our Western states had made a particular emphasis to bring in the deaf community. And they were so surprised that anyone would make specific outreach to them. And as a result, they were able to have a series of conversations to greatly improve the experience of parties that are traditionally extremely marginalized and removed from the situation. Finally, there's court culture and workforce resources, the entire container upon which a gender approach can work effectively. And you can see these various elements here of ensuring that that there are plentiful staff, that they're educated, they know how to perform their roles in a gender responsive manner, and that they have the resources that they need to execute their duties. And then finally, again, ensuring the responsiveness to various marginalized communities, especially, as I mentioned, because language access tends to be such a significant issue in courts. If we could proceed to the next slide, the area of greatest interest for us now, and I was really interested to hear the statistics, the data capacity that you have for collecting information. This came about because a number of judges across the country reached out to us independently. And when 3 or 4 judges from across the country reach out with the same issue, you have to think that it's more than a coincidence. And these judges were reporting that it seems that given the backlog that all courts are experiencing, the requirements that we have to hear criminal proceedings in a timely fashion, it appears that some of the interest, some of the staffing that we had available to preside over gender violence cases has been diverted to other case types. And we feel, though we don't have the data to support it entirely, we feel that this is impacting our ability to respond to the victims of violence. So in that inquiry, we convened again a number of courts from across the country, and we began to look at commonalities and some of the issues that various courts were experiencing with regards to data. And it was a very superficial analysis that revealed that significant data elements are not collected in a systematic manner, but they are of significant importance. And I provide a couple of examples here, such as parties present, specifics about postponements, what are the reasons for continuances, and what are some of the elements that would identify the same individual within the court system. This is particularly important because it's not uncommon that parties will present in one court and then perhaps they have another criminal protection order case or another case that has extreme relevance on the case for example, an order of protection, but those cases live disconnected within the case management system, and that prevents the judicial officer from making the best judicial decisions. So in this effort, we began to construct, and I offer it here, it is in draft form, but perhaps it offers a helpful overview of some of the data standards that we have constructed for domestic violence cases. And as you've probably noticed, I often refer to domestic violence. That tends to be the term that we most commonly use when addressing gender violence within the United States. And so these standards are comprehensive, extremely comprehensive, but what they are intended to do, as we did with these participants, representatives of various courts that came together in this dialogue, it's intended to represent the various elements that will facilitate data sharing across jurisdictional lines. And it is in the participants of the lab, of this backlog effort, reported that having these data standards has been helpful in their jurisdictions, and sitting down with the head of their statistics department and saying, here are the various elements. Are we able to collect these elements? If not, why not? What are the research questions that we would want to answer, but we find ourselves unable to do so? How would we construct a plan to be able to collect that information, to be able to answer the questions that we have and ensure that we are applying an equitable process to all, and that we're not creating systems where cases are delaying without necessarily being aware of it. So if we could proceed to the next slide. We stand with you in the pursuit of a gender approach in justice. If any of these materials are of interest, we have various materials about the application of technology. Certainly would appreciate the opportunity to continue in dialogue. So thank you very much, Dr. Palma.
Thank you so much, Ms. Davis, for describing so clearly the functioning of the services, stressing the utmost importance of an institution and a user-centered perspective, considering governance, the user's voice, and the court culture. Now we continue with the following theme. Please, Ms. Evgenia Bondarenko.
Дякую, доктор Пальма. Ну що ж, ми переходимо до
Thank you,
нашого.
Dr. Palma. It seems that it is high time to proceed with our third panel. We have had an opportunity to talk about practices of international judicial institutions and proper consideration of gender-related issues. However, I am sure that national professionals can have their say in this discussion too. Unfortunately, I would say, because as Ms. Christina Kitt mentioned today, in the recent months, Ukrainian judges have more and more situations where they need to face these gender-related issues due to the great number of war crimes committed in Ukraine in the past years. Our next speaker will be Nadia Stefaniev, judge. She's a very experienced judge, and I think she will have much to share in terms of gender-sensitive issues. Thank you very much, dear organizers, dear participants. Thank you for having me here. Thank you for displaying my presentation already. As you can see, the topic of my presentation is gender sensitivity in adjudicating war crimes cases. This is unfortunately a very topical issues in Ukraine these days. I tried to combine two components in this presentation, which are gender sensitivity and adjudication in war crimes. Next slide, please. So war crimes is a new type of cases which emerged in Ukrainian courts. In order to be able to adjudicate in such cases, Ukrainian judges get trained on international humanitarian law, on international criminal law. They look into the decisions and judgments of international tribunals, of international ad hoc tribunals, which were established at the end of various military conflicts all over the world. I would want to touch upon the issue of vulnerability of victims and witnesses, which is unfortunately always part of war crimes. It comes predominantly to women and children, civilians, because civilians suffer more than any other categories when an armed conflict takes place. And as I said, the most vulnerable categories are, of course, women and children. They suffer the most. There are many of such cases pending before Ukrainian law enforcement bodies nowadays. So the investigations are ongoing, and many cases will be submitted to courts in a short perspective. The judiciary needs to be prepared to consider and adjudicate in such cases, but also to properly treat victims and witnesses, properly treat their statements and evidence provided by them, especially if they are collected in other manner than the one prescribed by the current criminal code. We need to understand that sometimes it is not possible to stick with the letter of law in terms of collecting evidence in war crimes. It is in general quite difficult to collect any evidence at all when it comes to war crimes. Victims are and witnesses are reluctant to get in contact with law enforcement authorities. So one need to make an effort in order to detect potential victims and witnesses. Thus, the court will need to assess evidence through a very particular and uncommon from a very particular and uncommon angle in order to see whether the manner in which evidence was received is acceptable, and whether such evidence can be properly taken into account when adjudicating a case. This is all about gender sensitivity, among other issues. I've recently took part at an event dedicated to children as victims and witnesses of violent crimes, including war crimes. By the way, we are talking here not only about teenagers, but also about very young children who have gone through a very traumatizing experience. And I have to state that in Ukraine, some first steps have been made in order to put these children in more comfortable conditions to make them witness in a more effective, to give them an opportunity to witness in a more effective and safe manner. So this system of Barnahus centers is being developed across the country. So these centers are intended for young children, for teenagers to have the possibility to get interviewed by first responders, but also to take part in court hearings from some safe space. Now, speaking of armed conflict and women in the context of Russian-Ukrainian war. So violence, including sexual violence, has been recognized as a weapon of warcraft applied by the Russian Federation. So all cases of sexual violence, rapes that are committed by Russian soldiers, they're not just general crimes, but this is the method of warcraft. So it has been acknowledged as such, and it means that such crimes can not be tried under the criminal code of Ukraine. Such crimes, in my opinion, need to be qualified as the international crimes, and violations committed by the perpetrators need to be interpreted as the violation of international provisions. So the crimes, war crimes, sexual crimes, which are being committed in Ukraine, constitute challenges for Ukrainian judiciary in terms of identifying the perpetrators in the first place. Thus, at the stage of pre-trial investigation. This is why the judges need to be informed about such peculiarities in the framework of the training. They need to be prepared to the fact that in the majority of cases, the perpetrators go non-identified. Besides, Ukrainian judges need to be trained to use international documents, including those containing elements of crimes. The next slide is dedicated to the admissibility of evidence. So the court may use as evidence data from open sources, from e-sources. However, the court will need to assess the reliability of such evidence. And if you look at the practice of international institutions, including ECTHR, we will see that the admissibility, even though the admissibility of evidence is usually governed by national provisions, the ECTHR, for example, assesses if the proceedings were just in general, and on whether the proceedings in a case had not violated the principle of justice in general terms. We were listening to Martin Hackett, who said that the judge need to assess evidence, the whole evidence in their whole scope. It is indeed a very complicated and painful situation if a judge can see clearly that violation had taken place, that a victim had indeed suffered and went through a very traumatizing experience, but the evidence had been collected in a manner which does not allow for admitting them, and the court cannot come up with the guilty verdict. It is indeed very difficult. It is very painful, and it is something which is quite difficult to explain to the claimants. In order to avoid such situations, the evidence in war crime cases, especially when it comes to sexual violence, need to be collected in a very prudent manner, with proper observance of international standards, so that evidence are admissible, or at least the chances for admissibility were quite high. Besides, I cannot but mention that the applying the Berkeley protocol is highly advisable. It is not a mandatory document. The protocol was presented by a very renowned institution, which is the University of Berkeley, back in 2020. This is a live document which is being constantly updated. However, as I said, it is not mandatory, but in my opinion, its provision should be taken into account. Let me remind here that the Berkeley Protocol provides for the possibility of use of evidence which are available in open sources. The ECTHR has not come up yet with an opinion on the admissibility of such evidence. However, we cannot but acknowledge that it happens quite often that the clear evidence of violence committed in respect of various vulnerable categories become available online. And I do hope that at some point in time, very soon, it will become possible to collect evidence based on the Berkeley Protocol and to acknowledge them as admissible.
Вже сказали про інтерв'ювання потерпілих представниками
I already
громадських.
mentioned about the interviewing by CSOs, the testimony that needs to be given only once. And the next slide that I'd like to finalize with about terminology. Unfortunately, we don't have enough gender-sensitive terminology in judgments and in state documents. Therefore, I guess, first and foremost, we must not have gender blindness. We must be impartial and we must be gender sensitive. Just the last slide here. Why I wanted to present this last slide. Here there is some sort of the gender sensitivity, gender sensitive cases, and gender sensitive court, both in terms of cases and institution. And the same should be the court decision. Thank you for your attention. I can see some questions in the chat. Thank you, dear Nadia. So far, there are no questions directly to you. Thank you so much for touching upon these important issues. And it's, of course, difficult to be very brief when it comes to war crimes, especially topics related to women, children, and the whole Ukraine is now sensitive. I'd like to give the floor to key international expert of EU Pravo-Justice project, the judge of International Court of EU Mission in Kosovo, Anna Adamska-Galant, who has wide legal experience and judicial experience, especially in these cases. Dear Anna, the floor is yours. And dear speakers, please meet the timeline for everyone to be able to present their contribution. Hello, everyone. Thank you so much for the invitation. I'll be speaking briefly because there are a lot of important things have been mentioned. I'm trying not to say what has already been told. I want to cover a couple of words about women judges because in war crime cases, the experience shows that women played an important role. They changed the approach to the crimes related to gender violence. They helped to define such crimes as tool of armed aggression, and also they were recognized as war crimes. That's a very important change, and it shows that gender balance also is important in courts. As it has been mentioned by Justice Stefani and by other speakers, gender violence or sexual violence, unfortunately, is always a part of the armed conflict. Women, girls are always most vulnerable. There is the danger of it that they can become a victim of sexual violence. We must remember that women remain alone. There are no men who went to fight the war. They are very much at huge risk of sexual violence, and the threat of sexual violence it comes not only from combatants but from other people who use such circumstances of the war in order to commit this sexual violence. Women are at the core of these events and of the focus of international criminal law. They are the most common victims of displacement, and they are the most often victims of sexual violence cases. As we see, its first international court as far as Nuremberg Tribunal and Tokyo Tribunal, the issue of gender violence or gender crimes or related to armed conflict didn't matter. Such cases weren't heard there. No victims of sexual violence were heard and considered. Also, it's important that these courts didn't have women judges, and this approach was changed only in the beginning of 1990s when there were the wars in former Yugoslavia and this civil war that happened in Rwanda. ONU resolution that were the basis for creating international tribunals for former Yugoslavia or for former tribunal for Rwanda provided for the fact that gender violence has to be the subject matter of investigation, has to be the subject matter of court hearings. What is also very important, the Rome Statute provides that there should be the fair representation of men and women amongst the judges to guarantee this gender balance. The way we put it, or when we think of women judges, we understand or we see that they're more sensitive and they better understand the degradation that the victims of war crimes will have to face. It's not just two words that women are more sensitive when we speak of sexual violence. Here on the slide, in the slide, you can see a number of the most renowned judges of national courts and tribunals that were very important in changing the approach to sexual violence. how sexual violence is viewed in this courts. Patricia Wald, the judge of former Yugoslavia, showed that women have unique experience how to change situation for the better. And Judge Navanetam Pillai, the only women judge who sat on the tribunal for Rwanda, appointed in Jean-Paul Akayesu case, and she managed the collection of the testimonies in gender violence. It should be emphasized that Akayesu case was the first case on genocide that actually recognized that sexual violence can be part of genocide. Also, Elizabeth Odiot Benito made prosecutors change to the indictment in Dragon College and add the charges related to gender violence. Judges Teresa Dugetti and Julia Sabutinda, who worked in the special court for Sierra Leone, and Patricia Sellers, she was a prosecutor who worked in Rwanda cases and former Yugoslavia cases, and she drafted this or developed this legal argumentation that led to the adoption by the tribunal of milestone judgments that recognized the sexual violence crimes as part of genocide, as part of other types of international crimes. It shows that women judges can take decisions irrespective of any bias or assumptions about the nature of women and her sexuality, and they have to be very sensitive to victims who have to testify about the most traumatic events in their life, and they ensure protection of victims from the violent treatment during the case and investigation. And women judges show an example to males and investigators how to work with sexual violence victims. To finalize, I want to emphasize some standards that were adopted in these two tribunals, International Tribunal for former Yugoslavia and Rwanda, where cases related to sexual violence and gender violence were very important. It was necessary to emphasize that victim-oriented approach that we spoke about, that we already introducing in Ukrainian courts. It's very important to protect the victims from violent or cruel treatment during the examinations and the hearings. In these two tribunals, they also adopted certain rules related to the collection of evidence. For example, the testimony of sexual violence a victim do not need to be corroborated. It's very important because in some societies, for example, it was necessary to have 3 or 4 witnesses. It's also the prohibition of using the presumption of consent to a sexual act and also any previous sexual behavior of the victim. Considerations are not accepted. It has to do with how we hear the victims of sexual violence cases. International Court adopted a number of practical decisions that help protect vulnerable witnesses and victims, how to protect them, how to make sure that they're not re-traumatized. That's all on my part. Thank you so much for a chance to be here. Thank you for your time. Thank you, Anna, for your address. Thank you for drawing attention to such important issue as the standing of a women judge, because we see it always from the standpoint of victims and witnesses, but to consider such cases and to be impartial, That is a real challenge. Now, to moderate this panel, I'd like to again give the floor to Dr. Palma for him to present the following speakers. The floor is yours.
Thank you so much, Ms. Bondarenko. Please, Mr. Stanislav Petrenko, Prosecutor of War Crimes Department of the Office of the Prosecutor General. The floor is yours.
Дякую. Вітаю всіх. Висловлюю свою вдячність USAID за можливість взяти участь у цій
Hello,
конференції.
thank you so much. Thank you, Said, for having a chance to attend this conference. And I'll speak on the issues of the war crimes issues. I represent the Office of the Prosecutor General, and our unit has to do with preventing crimes that are committed during the international armed conflict by the representatives of the aggressor state and the units controlled by it. For all of us, it's clear that international armed conflict has posed a huge task and challenges before the law enforcement agencies of Ukraine, and if we don't ensure our self-development, then our law enforcement system will not be able to function effectively in order to identify, track, record, and bring to responsibility the perpetrators of international crimes, of crimes against humanity, and has some genocidal traits on the territory of Ukraine. What is important here is to take into account the persons who are victims and witnesses in a criminal proceedings. I already communicated on this topic, and I can highlight that unfortunately, traditionally in the criminal justice system, especially for the law enforcement agencies, the interest to the person of victim and witness was mostly limited to the fact that this person is the source of some testimony in criminal proceedings, and there wasn't given enough attention to what the person had to go through, what horror she had to experience, and how the law enforcement agencies can help. This question was not posed very often. And while we tried to counter war crimes, we started actually making sure that we properly address this issue. Due support for victims and witnesses is one of the strategic goals that is present in how to counteract war crimes in the territory of Ukraine, and it has a specific list of actions that the law enforcement agencies need to take in order to ensure a better investigation. And within these measures, one of our tasks is to look for victims and witnesses proactively, trying to identify ourselves persons who may have suffered because of the international armed conflict in order to get information and to provide help to them. Also, it's important how to make sure that the persons are not re-traumatized, because unfortunately it often happens that the same person is investigated for many times and is involved in too many investigative actions that actually re-traumatizes a person and leads to the fact that the person needs to experience the same traumatizing event again and again, over and over. We understand that this must be minimized. We must take measures to make sure that the person has the most user-friendly interaction with the law enforcement agencies, and so that he or she can recover from the horrible moral damage and other damage he or she suffered. Therefore, the Office of the Prosecutor General has actually created the Coordinated Center for Victims and Witnesses, a new structure that didn't exist before in the structure of the Office of the Prosecutor General. And this center is about providing psychological and professional help to persons who suffered or who witnessed international crimes. And here we are trying to implement the best practices of international organizations, and we understand here that a person or a victim has to be protected, and justice needs not only to pursue the perpetrator to responsibility and accountability, but also to protect as much as possible the person who has suffered because of the crime. And such are the steps by the Office Prosecutor General, which are important, and in my deep conviction that they are relevant for the challenges that we have right now. Also, during our conference today, we heard a couple of times the issue of countering the sexual violence crimes during the armed conflict. It also is highlighted as the priority one within our War Department. In the Office of the Prosecutor General, we have specialized department that conducts procedural overseeing over the sexual violence war crimes. Here we need to pay attention to the fact that unfortunately sexual violence covers not only rapes of women or such damage, but also sexualized crimes in such when the persons are held captive. Unfortunately, it happens again and again against men, and it shows that international crimes are one of the most horrendous manifestations of the unlawful behavior that influences each and every person, irrespective of his or her gender, sex, age. And the task of the national law enforcement authorities, and we are here also gaining support from international partners, is for Ukraine to maximize its efforts for it to be able to counter these types of crimes as efficiently as possible. Thank you so much for giving me the floor and for having me here today.
Thank you so much, Mr. Petrenko, for your presentation, making such a crucial elaboration on the relevance of the management of the sensitive matter in war crimes cases, enhancing the importance of user-friendly interactions and related services. Please, Ms. Sonia Prostran, Chief of Party, USAID Judicial System Strengthening Activity, East-West Management Institute, Uzbekistan. The floor is yours.
Thank you, Luis, and thanks to the colleagues from USAID Chemonics in Ukraine for this opportunity to speak at this conference. A lot that I actually wanted to say this evening has already been said. So therefore, my presentation will be basically very brief. And from all that has been said, I would basically like to focus or to refer to previous three speakers, to Anna, who has spoken about the importance of the judicial, of the gender parity or gender equality in the supply side, so to say, or in judiciary or in courts. I would like to also refer to what Martin was saying about victims of violence, sexual violence, and other forms of crime, which are related to gender, and also to some extent to what Alicia was saying about certain vulnerable groups. With respect to women judges, and speaking basically from the experience of the country that I currently work and live in, and that is Uzbekistan, I would say that creating Women Judges Association is, regardless of the number, actual number of women in a certain court system, is basically vital to preserve or to maintain and also enhance the position of women in judiciary. And I will explain why. If we look at the statistics of even of the very developed countries, we will see that even in those countries where women are more than 50% of judges, they do not take that many positions as court presidents. They don't take as many positions in courts of higher instances, of the courts of second instance, or in the Supreme Court. So basically, the advancing in the career, the promotion, or the career path in general for women in judiciary is, I would say, much more difficult, or with more challenges than for men. Secondly, women judges associations across the world basically deal with the issues related to vulnerable groups, and they deal with, sensitizing the entire court system, but also the entire societies to the vulnerable groups, including victims of gender-based and sexual violence, but also people with disabilities, etc. In that sense, I would say that whether it is formalized as an and registered as association, or whether it is an informal group, a club of women judges, this kind of organization based on the principle of sisterhood is basically very important for maintaining the position of women in the judiciary, but thus also in the society. On the demand side, on the side of the court users, I would say that training of judges on how to deal with vulnerable groups in the courtroom, training of prosecutors, how to deal with them during the investigation, and finally with the police officers who also investigate who also investigate these crimes is perfectly okay. It's really probably the best thing that we have right now at hand, most of us coming from various parts of the world. But pardon my French, if I may say, that cannot really be very sustainable, because these trainings should be repetitive given the turnover of personnel in all these professions. It means that, trainings have to be supplied over and over again. And also given the limited budgets of the national institutions, given that very often these trainings based on the donors' assistance, I would say they really lack sustainability. So what is it that we can do to surpass this challenge? What we've done in Uzbekistan, we basically put together in the same room the representatives of vulnerable group and women judges, but outside of the courtroom. This was just the same room, and made them speak, actually made them talk to one another, let the representatives of vulnerable groups speak about what they have been through, let the CSOs who have been working with the victims of various crimes, but predominantly gender-based violence, speak to judges what types of cases they have been dealing with. Most of them, mind you, never reach the court. It is some general statistics that only about 10% of all gender-based crimes ever reach the court. A larger percentage reaches the prosecution. But most of these victims actually turn to informal solutions. They prefer to talk to more open or structures, such as NGOs, than to go to the police. I think that this was far more effective than the training. This and role play. We actually made judges be, in the role play. We actually made judges play the role of victims of a crime, and this resulted in some really great results. To that extent that there were judges who would really, break down and cry when they actually realized, in very artificial circumstances, what a victim of a crime really, of a gender-based or sexual crime, goes through. One there is one also effective example from a neighboring country, but also Central Asian, from Kazakhstan. The Kazakhs developed an app for police officers, and their police officers, they all use basically tablets or iPads and carry them with them. So they have installed an app in this device, which gives them guidance on how to treat victims and witnesses of different crimes. And quite large section of this app is dedicated to domestic violence. And this app contains questions and sexual crime, questions that shouldn't be asked at any circumstances. Also guidelines on how to behave with victims of these crimes, how to avoid repetitive victimization of victims of these crimes. And it seems that this app is very useful, doesn't really reflect the statistics of the overall prevention of gender-based violence, but at least there are more and more cases which get and more victims that get the court protection, and more police officers that are really aware of how to treat these people. Last but not the least, what we also kind of achieved is, and I would refer to what Alicia was saying about the deaf community. The deaf community, this is really, I would say, everywhere in the world, a forgotten or really marginalized community. And we managed to put together female judges with deaf women, representatives of the deaf community, who were able to speak not only about the challenges they face when they come to court hearings as witnesses or victims, but also they were able to speak about what they really go through in their families, what are the specificities of them suffering the domestic violence, etc., etc. So this is also one of the interesting experiences that I would like to share with you. Finally, I think that fighting for the gender equality in judiciary, or implementing the gender approach in judiciary in general, is actually a fight against stereotypes on all levels, and one mustn't forget that. It's, you know, I was a judge for 16 years, so I know what I'm talking about from the inside. I know what I'm talking about from the perspective of someone who has worked in the war crimes court and has been in touch with the victims of war crimes, including rape and other types of sexual violence, as I was also one of those who established Victims and Witnesses Support Unit in the War Crimes Court in Belgrade. So I know what. So this is always a fight against stereotypes on all levels, and that I think I'm actually very happy to see a large number of men in our conference today. This is usually not something that I have been seeing lately. Whenever there is a gender as a topic, whether it is an international or local conference, usually the most of the participants are women. This doesn't concern us. We know very well what we stand before, but it is basically the stereotypes that we have to fight. Lastly, I have just one, I would say, a question or dilemma for my Ukrainian colleagues with respect to the victims of sexual war crimes. What we have faced, or actually what happened in Bosnia, was that there was a lot of work with the women victims of sexual crime during trials. But I have seen none, or to a very limited extent by some individual enthusiasts, I would say, sometime afterwards. Because what happened is that the perpetrators served their sentences in prison and they went out. And the victims were basically forced to meet these people in the street. And no one was there to offer them any psychological support. So this is like for the health of the community, for the health of nation, this is something that the governments basically have to think through and provide support to these victims beyond the trial. Thank you very much. Дякую.
Thank you so much, Ms. Prostrom, for sharing your great national and international experience and for providing us such a comprehensive view. This highlighting the leading role of women judges associations as it relates to vulnerable groups in the courtroom, bringing into consideration the Kazakhstan impressive experience, and stressing the necessity of role play and repetitive training to contribute to change the culture in the best desirable manner. We have no questions in the chat box and no hands raised. So we want to thank you so much for your excellent and deeply engaging presentations which picture remarkable developments and achievements in the gender approach to the justice system, gender-sensitive case handling and dispute resolution, state-of-the-art on the field through the best international practices, and war crimes adjudication, all to make possible the continuous improvements of the justice services for the people. I don't know, seems to be a technical problem. Okay, it's okay. Thank you all for being such a committed audience. Soon we'll post the conference recordings on the IACA website, on the IACA YouTube channel, at IACA/Word. Please stay tuned. Looking forward to meeting with you soon again. We wish you a Merry Christmas, Happy Holidays and Christmas, and a wonderful New Year. Thank you all so much. Have a great day.